Hello, everyone, and welcome to our U.S. Cyber Law Senior Project here. Currently, we are doing the data privacy in Michigan. I'm Nathan Butgereit.
I'm Chris Liberman.
And I'm Mason Servant.
So to start off, why do we need data privacy? Currently, there is a lack of federal guidance in the U.S. There's a large split between federal and state. So there's no accountability currently and no incentive to protect consumer data. So all the burden of the protection falls upon the backs of the consumers. And there is currently abuse of exemptions and loopholes in the existing law that need to be fixed. And we assert that here in the Michigan Privacy Rights Act. So what makes a good policy? We have worked on user rights, where the information is held, who has access to it, and that individual knows everything about that. They can either opt in or opt out. We talk about jurisdiction in Michigan and outside of the state, and then the adaptability of the policy as well.
Our bill borrows heavily from two other bills that exist already. The first being the California Privacy Rights Act. That is, California was the first state to enact their own privacy rights bill, specifically for personal data collected over the internet or through other services. So right now that act offers users the right to know when their data is being collected and to opt out of it. And it provides a fairly comprehensive definition of what personal information is. So it incorporates a lot of different types of data, but it's not all encompassing. For example, it only applies to residents of the state and not to workers or people who are visiting the state. We also borrow heavily from the European Union's General Data Protection Regulation, the GDPR, that offers a bit more of an extensive coverage of personal data. It allows users the additional rights to access their data that's collected and delete it if they want to. It also provides some limitations on user consent so that you can't give away your rights. And it also requires that companies inform their consumers of any data breaches when they occur within a timely manner.
All these aspects come together to form the Michigan Privacy Rights Act, accounting for points such as user consent limitations, so the user agreements must be reasonably fair to the average consumer and the rights cannot be waived. Data control, allowing consumers to be notified of data collection and usage, have the right to opt out, request, and delete said data. Establishing a consumer privacy fund to cover court fees incurred by the state to enforce consumer privacy. Also creating a Michigan Privacy Protection Agency, so a state-sponsored institution to enforce data privacy regulation through audits and risk assessments. Also allowing for data accessibility with streamlined methods for requesting personal data at no charge with no additional data collection from the request given in clear language. It also encompasses child privacy, so extending the COPPA age limitation to 16 years of age and requiring explicit permission to opt into data collection rather than opt out for children. Also including breach notification and relief, which allows for timely notification of breaches involving personal information with fiscal relief given to if proof of damages incurred provided by the consumer, and allowing for exceptions to comply with federal, state, and local laws and exemptions for specialized cases and circumstances. Thank you for watching our presentation.